Law enforcement across California treats certain dates as high-priority DUI nights. New Year's Eve, the 4th of July, Labor Day, Memorial Day, and Thanksgiving through Christmas are the heaviest periods. Around those dates, you will see more officers on the road, and many of those shifts are paid for by traffic safety grants that exist specifically to fund checkpoints, overtime, and saturation patrols. The California Highway Patrol also declares maximum enforcement periods on major holidays, putting as many officers on the road as possible. None of this is secret. Much of it is announced in advance. Sobriety checkpoints are a favorite holiday tool, but they come with real constitutional requirements under California law. Supervising officers, not the officers in the field, must make the key operational decisions. The location, timing, and the formula for which cars are stopped must be set by neutral criteria decided in advance, not by any individual officer's judgment. The checkpoint must be properly marked for safety and publicized ahead of time, and each stop must be brief. When an agency cuts corners on those requirements, the stop itself can be challenged in court. At a lawful checkpoint, you do have to stop and provide your license, registration, and proof of insurance. But you are not required to answer questions about whether or how much you have had to drink. For adults, the roadside field sobriety tests and the handheld roadside breath device, called a pass device, are generally voluntary. That handheld pass device is not the same instrument as the evidentiary breath test at the station. It is a screening tool the officer uses to help decide whether to arrest you, not the result the prosecutor relies on in court. Being calm and polite, while not volunteering evidence against yourself, is not obstruction. It is simply exercising your rights. Checkpoints get the headlines, but saturation patrols catch more people. A saturation patrol is simply a concentration of officers in an area actively looking for reasons to pull cars over, with DUI as the goal. That means minor things like a brake light out, a wide turn, or a brief touch of a lane line become the doorway to a DUI investigation. The first question worth examining in any of these cases is whether the initial stop was actually justified. If the reason for the stop does not hold up, what happened afterward may be challengeable through a suppression motion. Here is something worth knowing. On a high-volume enforcement night, officers are processing many people quickly, often outdoors and under pressure. Observation periods get rushed, paperwork gets sloppy, field sobriety instructions get abbreviated, and checkpoint procedures that look fine on paper are not always followed in practice. All of that creates openings for the defense. A holiday arrest is not a stronger case against you just because enforcement was heavy. The proof is still worth examining carefully. If you are arrested over a holiday weekend, there is one practical trap that catches people. You generally have only 10 days from the date of your arrest to request a DMV hearing to contest your license suspension. Weekends and holidays count toward that 10 days. If you are arrested on a Friday of a long weekend, you do not have extra time just because the courthouse is dark. The DMV clock keeps running. That deadline is separate from your criminal case, which is why it is easy to miss if you are focused on the court side of things. If you or someone you care about is arrested during one of these enforcement waves, do not assume the case is settled before anyone looks at it. Results vary, and the facts of each case are different. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.